exportação das chamadas commodities, não é? São 100 bilhões de dólares por ano que o Brasil vem exportando. São interesses muito poderosos que, evidentemente, têm uma representação muito forte no Congresso Nacional, que em 2012, há 4 anos atrás, conseguem aprovar no Congresso Nacional uma reforma desse nosso Código Florestal de 1965, que é um retrocesso terrível, né? Porque é um projeto que, desde o início, foi atacado pelas instituições científicas, pelas organizações ligadas à proteção do meio ambiente, mas que, contra tudo e contra todos, se impôs, foi aprovado no Código, no Congresso Nacional, e traz, assim, em seu bojo, alguns retrocessos terríveis. A entrada em vigor dele foi questionada desde o início pelo Ministério Público, que ajuizou 4 ações de inconstitucionalidade contra diversos de seus dispositivos, mais de 40 desses dispositivos, e essa questão está agora sob júdice, e o ministro Luiz Fux, do Supremo Tribunal Federal, há menos de 15 dias atrás, há menos de 15 dias atrás, realizou-se uma audiência pública convocada pelo ministro, que levou a Brasília representantes de diversas associações e das classes produtoras rurais, enfim, para que ele, como relator do caso, pudesse formar a sua convicção em relação ao Código, a essa nova legislação. É evidente que, do lado de lá, os argumentos são ad terrorem, né? Fala-se em segurança alimentar, fala-se em segurança jurídica, que eventual revogação de alguns desses dispositivos trariam para o campo brasileiro e para os produtores rurais, não é, uma enorme situação de insegurança jurídica, enfim. Mas o fato é que esse Código Florestal, essa nova legislação florestal, por que ela está sendo contestada, e por que ele está sendo contestado, e por que ele deveria, e o que é preocupante? Aí eu acho que é preocupante não só para o Brasil, né, mas eu acho que é preocupante também para o planeta, né, na medida da importância do Brasil na preservação desses recursos, e foi isso que me fez trazer aqui essa questão. Um minuto, yes, thank you. Thank you, Mr. President. Primeiro, anistia para os desmatadores que, ao longo desses anos todos, descumpriram o Código Florestal, a possibilidade de que se desenvolvam atividades econômicas nas chamadas áreas rurais consolidadas, que foram essas que originalmente deveriam estar cobertas por florestas e que foram usadas na agricultura, as nascentes d'água intermitentes, que são tão importantes para o Nordeste brasileiro, se retirou a possibilidade delas serem protegidas, que havia na legislação anterior. Isso vai ser um desastre ambiental que o Brasil está criando agora para atender a esses interesses. A possibilidade de compensação ambiental daquela área de reserva legal a que eu me referi, fora da bacia, isso eu não vou me estender muito, não. Os manguezais, que também objeto de uma atividade econômica assim, muito forte, que também agora perdem boa parte da proteção, e as margens de lagos e lagoas. Ou seja, essa legislação atual brasileira, em relação à água, em relação a florestas, tem sido assim um atraso que devia preocupar muito, eu acho que instituições ligadas ao meio ambiente no Brasil e fora dele, pelo menos é a minha opinião. Muito obrigado pela sua tolerância.
Muito obrigado, Fernando. Now we will do as we did in the previous round. I will open the floor for questions or comments, and I'll take here. Then we will go back to Spencer over there. 1, 2 is third, and the third one here. Yeah.
Vou falar em português.
Please do.
Meu nome é Rodrigo Rosken, eu trabalho na SEDAI, a Companhia de Água e Esgoto aqui do Estado. Uma das grandes dificuldades que a gente encontra hoje é como conciliar proteção ambiental com danos que já foram historicamente sendo consolidados. Então, o Rio de Janeiro é um exemplo claro disso. teve um crescimento desorganizado e resultou em danos ambientais que até hoje estão aí. Como que com instituições como as nossas, com falta de organização, com falta não de legislação, que como o senhor mostrou, tem legislação, mas como resolver esse tipo de problema de natureza tão grave, social e ambiental?
Tá. Muito obrigado. Pode passar para lá? Obrigado.
Thank you. Spencer Thomas from Grenada. I have a question, and thank you for the presentation, which I think was quite illuminating presentations. Professor McIntyre, in particular, I very welcome the information on the ecosystem approach and so on. The question I want to ask you is, maybe for you to elaborate a little more on the issue of the precautionary approach to ecosystem management. And given the time that this concept was around and the science has developed over all this period, what is the contemporary legal interpretation of the precautionary approach, and how has that evolved over time?
Thank you very much. If you could bring it here to the front, or just, yeah, thank you. Over there.
Thank you. My question is build the question on a couple of ideas. One is that here in the news in the U.S. a few days ago, I hear that a piece of the budget for the 2017 of the U.S. government is going to dedicate it to water innovation. I hear that it is the first time that is such a motive from the government to put some money into this area because of the worries that they may have for the future, and it is split in two areas. One is for studying the climate, so they want to understand better the supply side of water, and the other one is innovation to bring the price of desalinization to the actual price of taking the water from rivers and lakes, which is a major issue for future legislation, I think, for the whole world. This is one thing, and the other thing is a report from the World Bank indicates that there is a tendency in the case of Latin America, if they take the data from 2012 projected to 2050, that amount of energy that we need from this growing process of urbanization, we may need 550% more energy for Latin America, which means 360 more water dedicated to having this energy. So my question is, what kind of legislation or what should we do from the environmental rule of law should do it now for preventing the potential disputes for water for the people, for potable, for food, for energy, and for all these needs that are going to become growing and growing? Are we prepared for that?
Thank you very much, Max. May I suggest that we start with Owen, because there was one question that was specifically directed to him, but of course you are also able to make what? Yeah, but not now. In the second round. So, Owen, start with the question and anything else that you may want to comment, and then we will come with Luis Fernando and Fernando.
Okay, I will address specifically the question about the precautionary principle. Well, it's a very interesting question, an excellent question. You know, the precautionary principle, though it is 30 years old really now, if thereabouts, is still a contested idea. I mean, I prefer principle than approach, and that maybe reflects a European versus an American understanding of it. We tend to give it normative status in Europe. It's written into the European treaties, for example, which are basically the constitution of the European Union. So we have long since given it legal status. The problem is it's contested. You know, what exactly it means. I'll come back to that point in 1 second. It's also abused. I get very frustrated where in its enthusiasm for environmental protection, the European Court of Justice, or Court of Justice of the European Union as it's now called, a healthy change, it routinely uses the precautionary principle where there is no scientific uncertainty. This was meant to be an emergency decision-making power to manage uncertainty. And where there was no uncertainty, you would err on the side of caution, etc. Whereas the European Court uses the precautionary principle when it takes the opinion that the legislation is not strong enough. And it cites the precautionary principle to implement legislation which is not on the statute books. And so it's almost judicial legislation. It's very frustrating, very abused. But when I say it's still contested, the point is this, that what we understood initially about precaution was this idea of, scientific uncertainty is not an excuse not to regulate. Our scientific uncertainty should, require the authorities to err on the side of caution, to take the measures regardless of the uncertainty. But that is not a standalone principle. What it actually needs is, in specific contexts, it needs substance. We need to add a substantive basis. And if we look at ecosystems or biodiversity law generally, that by developing methodologies around the protection of freshwater ecosystems, methodologies like flows, methodologies like the protection of ecosystem services, that then helps to give substance, helps to inform what kind of precautionary decisions we should be taking. That helps us to identify specifically where there is uncertainty, and in the context of that uncertainty, we err on the side of caution. So what we need to do is we need to develop the sector or issue-specific substance to allow us meaningfully to apply precaution.
Thank you, Owen. Luis Fernando.
Oui, sur les principes de précaution, je vais dire des choses. Est-ce que les principes de précaution doivent être éprouvés ou pas? C'est-à-dire, l'incertitude scientifique doit être éprouvée scientifiquement, c'est-à-dire, l'incertitude scientifique n'existait pas parce que scientifiquement n'était pas prouvé, parce que sinon, ça devient un problème d'application des principes de précaution. Lorsque on fait une application des principes de précaution, disons, sans aucun soutien scientifique, et seulement par les lacunes des connaissances de ceux qui appliquent les principes, c'est un problème. C'est la certitude juridique. Un problème des droits de l'environnement, c'est que les droits de l'environnement ne peuvent faire une déviance vers la méconnaissance du principe des droits. C'est-à-dire, les droits de l'environnement, ce n'est pas une porte ouverte pour tous ceux qu'on croit et qu'on veut pour protéger l'environnement. Les droits doivent revenir pour protéger la liberté et la certitude juridique des droits des personnes. C'est un problème. Par exemple, dans nos pays, en Colombie, même les aires protégées sont déclarées au nom des principes de précaution. Et le tribunal ont dit que ces aires protégées au nom des principes de précaution produisent une illégalité des contrats miniers spécifiquement. C'est-à-dire, l'objet d'un contrat devient illégal si il y a une aire protégée qui est déclarée au nom des principes de précaution. Et ça, c'est problématique. Et bon, ça c'est la question sur les principes de précaution, sur les problèmes du droit de l'environnement et la réponse de la loi. Disons, si vous en espagnol, c'est... mais enfin en français. Ça, c'est le problème des lois. Parce que je ne crois pas que la loi puisse résoudre tous les problèmes qui posent l'utilisation de l'eau dans l'énergie, dans l'agriculture, dans même de la consommation pour les personnes. Je crois que les grands défis des droits, c'est ça justement. Disons, les droits de l'environnement, parfois, dans la théorie, est très beau et très, disons, très facile pour les développer. Mais lorsqu'on voit, mais lorsqu'on va appliquer les lois de l'environnement, c'est pas facile. C'est pas facile parce que ça devient problématique à cause, j'insiste, sur la sécurité juridique et les libertés et même les droits de propriété, parce que, par exemple, on parle en Colombie, les problèmes, disons, des lois qui ont déclaré les aires protégées ont diminué l'offre de l'hydroénergie, c'est-à-dire, parce que c'est pas possible de faire de l'hydroénergie dans les parcs nationaux. Et toutes les régions qui ont un potentiel énergétique sont des parcs nationaux. Et ça, bon, la avait, il y a 20 ans, 25 ans, à peu près 65% d'offert d'hydroénergie. Aujourd'hui, ça, c'est à peu près 30%, et même ça va diminuer aussi. Et ça, disons, les problèmes de loi de l'environnement face à l'utilisation de l'eau et dans les autres aspects des ressources naturelles, c'est très problématique, non pas dans le domaine de la théorie, mais dans le domaine de l'application. Je crois qu'il faut passer de la théorie à la pratique. Et ça, c'est le nouveau défi, je crois, des droits de l'environnement.
Merci. Fernando?
Bem, no Brasil, essa questão colocada pelo Rodrigo é uma questão assim, extremamente preocupante, porque o que a gente pode observar, me parece que é o seguinte: enquanto o Ministério Público cresceu muito, ainda agora temos aqui a presença no auditório do Dr. Zé Rubens Morato Leite, que é o presidente do Instituto O Direito para o Planeta Verde, que promove um congresso anual de direito ambiental, que nós dois frequentamos há muitos anos, e é impressionante o número de promotores públicos e procuradores da República que a cada ano acorre a esse congresso para se modernizar, tomar conhecimento das novas questões ambientais. Então, o Ministério Público melhorou muito. O Poder Judiciário, com certeza, também hoje tem uma visão assim muito mais interessante sobre a proteção do meio ambiente do que tinha anos atrás. Agora, a legislação ambiental brasileira, ela está, não só esse exemplo que eu dei do Código Florestal e da legislação sobre água, mas, de um modo geral, ela está sofrendo um ataque muito violento no Congresso Nacional, de alguns anos para cá. Então, nós estamos perdendo várias conquistas que, alguns anos atrás, em congressos internacionais, falando pelo Brasil, eu tinha um orgulho enorme em falar das nossas leis, né, e hoje em dia isso não está mais acontecendo. E essa questão que o Rodrigo levanta, por exemplo, a questão do enfraquecimento da nossa administração pública, é extremamente preocupante, porque, principalmente numa situação de crise econômica, como a que nós estamos vivendo agora, tudo que o Estado não quer é investir, né, nessa área ambiental, é investir nas suas instâncias reguladoras, na fiscalização. Enfim, uma das questões que, por exemplo, que é importante falar aqui, assim, mais preocupante que tem a ver com isso, é que recentemente uma lei talvez pudesse até ser considerada interessante, porque ela atribuiu aos municípios brasileiros a maior parte da responsabilidade pelo licenciamento ambiental de empreendimentos potencialmente poluidores. Isso poderia ser até visto como saudável, né, na medida em que você estaria, as questões estariam ligadas a um poder mais próximo da população, dos problemas, enfim. Só que o Brasil tem mais de 5 mil municípios, e desses 5 mil municípios, se tiver 100 que tem realmente um aparato administrativo suficiente ou competente para lidar com essas questões ambientais, é muito. Então, nós vamos ter agora, né, mega projetos com grandes impactos ambientais sendo licenciados no nível local por estruturas administrativas que não têm simplesmente condições de enfrentar essa situação e que, evidentemente, têm o maior interesse em que esses projetos se instalem na medida em que vão trazer recursos, empregos, enfim, para os municípios. Essa é uma situação, viu, Rodrigo, que me parece assim, extremamente preocupante, mas você toca num ponto importante. De que adianta a gente ter uma boa legislação, né, se os órgãos ambientais estão diminuindo muito a sua eficiência no Brasil?
Muito obrigado, Fernando. We are approaching the end of the session, but I understand that there was a question here you wanted to make. It's fine. There is a last question over there, and with that one we will close. I don't know where is the microphone really.
I think it's gone.
Our microphone holder ran away with the microphone. I don't know. If you want to, the problem is if you do it without mic, it won't be translated. Come to the front, use one of these. But please be very brief.
My question
And the
is to
same for
Professor
the
Owen.
lady over there.
He had, extensively discussed on the ecosystem protection by giving reference of several international instruments. And today, in our part, we see several, fresh water diverted to other part through river linking and diversion projects, wherein the minimum water flow is not taken care of while diverting. So what would happen in case of such situation when in practical situation they don't care, keep maintaining the minimum flow of water, which will ultimately, seriously affect on the downstream ecosystem.
Thank
Well-
you very much. May I invite the lady over there to use one of the microphones here? And with the reaction of the speakers, then we will close the session.
Sure, indeed. Sorry for waiting for so long. I just wanted to hear all of the presentations and let the thoughts percolate. My name is Tara Smith. I'm a lecturer at Bangor Law School in North Wales. And actually, I had a question for maybe all of the panellists. While we were talking about water security, it dawned on me that actually a lot of other fields of law beyond environmental law were implicated. Humanitarian law, international criminal law, human rights law, as well as environmental law. But the thing is, none of those legal systems seem to be set up to deal with this particular issue. We recognise that environmental law may have weaknesses, and we've been discussing that, but human rights law isn't made to deal with water security. Humanitarian law has huge weaknesses, as you well know, actually, Carl. So in terms of kind of developing a comprehensive way forward to deal with this very serious issue that's, I suppose, going to become even more serious as climate change takes effect and so on, what are your best thoughts on ways forward to maybe link up those legal fields or develop a new way of working to try to treat the problem before it becomes a problem? That was my question.
Okay, thank you very much. We will start now in the other way around. We'll start here with Fernando, then Luis Fernando, then Owen. As we are already at the end of the session, I'd like to encourage you to be clear and succinct.
Very succinct. Na verdade, eu não saberia responder essa pergunta, não é? The answer to your question is very difficult for me because you are touching a very sensitive point of the weakness of our legislation towards water and the lack of taking into account these other aspects of the law. I don't know how to integrate this. Maybe it will require new approaches, of course, and new kinds of interdisciplinary studies and things like that. But I don't know specifically how this could take place now. Thank you.
Muito obrigado, Fernando. Luis Fernando.
Oui, c'est très difficile de faire la relation entre les législations et les différents domaines. Je crois que ce n'est pas seulement un problème de législation, c'est aussi des politiques, c'est aussi des jurisprudence, mais surtout des politiques. À la fin, le droit, c'est que le politique veut que les lois soient la loi. Je crois que le problème, c'est le politique, pas la politique, dans le sens français du mot le politique. Et parce que c'est une conception d'État qui est en jeu ici. Et c'est la conception d'État qui va déterminer la législation et la jurisprudence, mais aussi la connaissance scientifique. Et je me pose une question. Est-ce que la connaissance scientifique aujourd'hui est dans la voie de la protection de l'environnement ou la connaissance scientifique suit la voie traditionnelle de la science, c'est-à-dire d'une science positiviste, d'une science qui n'a pas en compte l'homme, l'humanité? Pour ça, c'est une intégration d'un nouvel modèle de société peut-être qui nous sommes en train de construire ou de détruire peut-être.
Merci, Luis Fernando. Owen?
If I take this question of water security, first of all, I think what you want to know, you raise a very key question, and it's underexplored by scholars. But it's very true that a range of other areas are highly relevant to the practice of international water law. International economic law, particularly investment law, human rights, humanitarian law, environmental law. But there's a difference between these bodies and international water law. These bodies, particularly human rights, humanitarian, they're absolute. They produce absolute obligations, or for international law, pretty clear and absolute obligations. Even investment law is very clear about the nature of investor protection and the liability that flows from a breach of investor protection. Now, that's unusual in the general scheme of international law. International water law is not of that character. It is an open textured norm. What it actually requires is a balancing of the interests of states. And around the principle of equitable and reasonable utilization, that means that you can take account of a whole range, limitless, open-ended range of factors, including potential exposure in investment law, including human rights implications, humanitarian implications, environmental implications, even the prohibitions we have in international water law on causing significant transboundary harm are flexible, they're fluid, they're due diligence obligations that are relevant and are relative to the circumstances and the conditions. So again, you can take account of all of these factors. So I think the infrastructure can handle it, if you know what I mean. You know, it can be integrated, but not nearly enough has been done to study, explore, and explain this. And the question, the very specific question on flows, the first issue is whether or not it's an international basin or a non-international basin. If it's an international basin, then the situation is surprisingly clear since the Kishinganga arbitration, that we have a very strong, from the Premier Court of Arbitration, a very strong precedent to say that regardless of what your convention says, because a 1960 convention like the Indus Waters Treaty said nothing about environmental protection, let alone environmental flows. And so the court turned around and they interpreted damage, and so the prohibition on significant harm, and they interpreted the overarching principle of equitable sharing. They interpreted those to mean that there was an obligation on states to protect environmental flows, minimum environmental flows. Well, that's where this is. But this is exactly the point.
I would encourage to follow that after decision.
I will. The point is, when the court in its interim award came back to the parties and said, you know, I want you to come back with submissions on minimum environmental flows, there was confusion. They had no idea. The parties went, well, where do we look for that? How do we, what, you know, where do we start for that? And in some ways, I would say that's our failure. There should have been clear, ecologically based principles to say this is exactly what minimum ecological flows. That's why the science, the academic literature, the scientific literature, the guidance should have that question answered when the opportunity comes up. Thank you.
Well, I ask you now. We are closing now. I encourage, I think that these are fascinating issues. I encourage everyone interested in those to follow these wonderful discussions and exchanges after the session is closed. Thank you. And I would like now to give a round of applause to our last three speakers. Mamadou, who led the comment.
Bon, ben, c'est juste pour vous remercier et vous féliciter pour la façon admirable avec laquelle vous avez dirigé les débats. Féliciter également les différents panélistes pour la qualité de leur présentation, mais également féliciter les différents intervenants qui ont contribué à enrichir les débats. Je pense que les débats sont ouverts. L'eau est source de vie, l'eau est très vitale, elle est liée à plusieurs activités économiques et socioculturelles. Elle est source de conflits, elle est devenue très rare, et donc il faudrait que le droit de l'environnement surtout puisse le prendre en charge. Mais je pense qu'il faudrait maintenant qu'il y ait une coalition mondiale. Il faudrait que aussi bien les décideurs politiques que la communauté de la conservation, mais également les juristes, que ce soit les doctrinaires, les professeurs, mais les praticiens du droit de l'environnement, puissent, avec la société civile, se mettre autour d'une table pour légiférer, avoir une très bonne législation qui puisse être appliquée de façon intelligente par les praticiens du droit. Merci.
Merci, Mamadou. I believe that the next session, well, it should start at 5:30, and you can choose again which one is the one that you want to follow. There is a coffee break that is arranged there and here too. Right outside to the left if you want to have a coffee, and then go to whatever session. And thanks very much to all the audience.